be sharing some good news to what happened yesterday and what's happening this year for Pakistan and the ecosystem for the center to resolve the disputes. But before I share a good news, there's a bad news and a sad news. Well, when I took a plane yesterday after handing over the arbitration law by speaking at this forum where the government committed to have the arbitration law after 84 years of Pakistan Arbitration Act 1940. Pakistan being the last country to have the 1940 law. India left the law in 1996. We are facing lots of issues on the foreign investment. So when I plane was taking off with Blunt and the team, I learned the person who made Pakistan ecosystem and made laws, my dear uncle, Dr. Tariq Hassan, passed away yesterday. My plane was taking off. I couldn't go back to Lahore, but I can just say he made banking laws with Shaukat Aziz. He was the chairman of SCCP. He was the advisor to finance minister. He made lots of reforms for Pakistan. And his family, the family is in the US. And my commitment with Mr. Shah and we have been going away all over the world to speak about Pakistan's platform on the issue of the foreign investment, arbitration, mediation. But I want to have 1 minute silence to pray for him. The good news, what heard Pakistan signing the mediation convention, Pakistan giving the law to the government, Pakistan coming in the map of the world. But what I will share is how, when I was just given recently a judgment on mediation and appointing the center of the IBA Center for Alternate Dispute Resolution, and Justice Dilani as the mediator in kind of series of judgments which has been passed first by my court, then Justice Yusuf Saeed followed that principles, then Justice Shahid Kareem followed that principle, then the Supreme Court also gave judgments which I'll speak to you on mediation. First issue is, what is Pakistan ecosystem? I was very happy to come to Karachi. When we set up the commercial courts for the ease of doing business in Pakistan, the first thing we looked into, I'm speaking to the 60% of Pakistan economy lies in Karachi. The entire business of Pakistan, the money comes from Karachi. We thought that we became a champion of setting up the commercial courts in Punjab. Lahore is just 25-30% market. Though, while looking at the Pakistan Index of Ease of Doing Business, I just came to know why we look bad, because the barometer of investment in a country are the corporate law firms. Any investor goes to a corporate law and say, how good is the judiciary of Pakistan? How good is the ecosystem in Pakistan? How bad are the courts interfering in the matters of arbitration? How bad are the courts doing delays in the matters of Pakistan? Do you have a more alternate mode to look into somewhere? That was the questionnaire that IFC and the IBRD and the World Bank and ADB was giving to the lawyers. And lawyers were filling up this form. When we set up the commercial code, we sat with them and said, look at it, your whole 20-page questionnaire was on a wrong presumption. We don't look that bad as you portray us, because everybody comes to you. They're giving you dollars to say, we want to invest into Pakistan. How good is it? But you have to say something. After yesterday's event, which we spoke, you will say that, look, there's an arbitration law coming in now. After the new judgments of Supreme Court of Pakistan coming into it, after our judgments are coming into it, and I want to say something candidly here, it's not governments have done something for us. It's our own judgments we are trying to implement. The entire ecosystem is based, the commercial courts was given by the government, and they took away the law because they didn't like it. Us doing something fastly, and then I had to give a Pizza Hut judgment to that 2021 CLD page 639 by saying that this is the Pizza Hut the chain, what you did to it, because we are the face of Pakistan. We have to represent, and that judgment stands and protected Pakistan because somebody who's not a lawyer, the only unique thing in Pakistan is the laws are made by the government under Article 70 as a law, federal government, the provisional government, or Article 89 as an ordinance. The bigger thing is the judgment of the Supreme Court of Pakistan. The Constitution of Article 189 says if a judgment of the Supreme Court decides a question of law, enunciates a principle of law, it's binding on the courts below. Same thing with Article 201. The ecosystem we have built, the commercial courts we have built, based on lack of the government support to us, is because of the judiciary itself led the way. Under the constitutional command, under the judgments followed across the world. When we look at why do you want center to be good, I want to thank the donors who took us to Singapore with Mia Gul, the accredited arbitrator. I want to thank them for Pakistan. His only question is, you have to have what London commercial courts did. When I sit as a judge in London commercial courts, the only thing they have is 80% users in London commercial courts are foreign parties. They trust the system, 100 years old. They're the best bright judges, like what we are sitting here and in their commercial courts and Rolls building. Why? SET, safe, speedy, effective, trusted dispute mechanism. They have their guidelines. We have to have centers to have a speedy, trusted, and with the confidence of commercial courts cannot go without the system support of the ADR, because they have a symbiotic relationship. Critical interdependence with each other. And Mr. Shah and I myself last week speaking with the entire commercial court judges, and we only have one thing to show, is a story of 5 months in 5 minutes. How I gave the judgment of mediation with the mandatory mediation, bullied mediation, directory mediation, intervene mediation, manage mediation, that you have to do it in the company law. The law does it because this is the approach of a Churchill case. That's followed by this Yusufzai. That's followed by other courts now. Look at the beauty of Pakistan, the judges are supporting each other just to build an ecosystem for foreign investment. Anybody comes to you and says, excuse me, can we invest in Pakistan now? Oh no, yes you can. You think the courts are delayed? Arbitration law is coming in, new law now coming in. You will not have a long delay in the arbitration law. What else you can do? We have the mediator concept under company law. These are regulators. There is a good judgment by Supreme Court of Pakistan, 2024, SCMR, page 640, the judgment of Shah on the TIC judgment, which clarifies the issue that you cannot interfere in the foreign award because it's not a local award. The TIC judgment, 2024, SCMR 640, and the other judgment of the RYK, where my Lord has given a beautiful view of saying that the ADR is the new concept in Pakistan. But what my Lord, again Justice Shah, in 2023 SCMR page 1103, the Sambhu construction case has said the 10 years delay in the award means the justice pipelines are choked. I'm putting a cost, and government should make the law on arbitration. This is not my speech. It was an overture or prelude to an opera. I'll start my speech now. May I have a permission? It's giving you a background. The issue is, what can we do now? ADR, Pakistan has a 1940 law. Yesterday when I was speaking to the public and telling them what I can look at, I only gave them 5 points, which you'll be very happy to know. I told this to people meeting me on the plane, and Jahaz-e-Vivan was a witness to it, and Heather was sitting yesterday in Islamabad when we were launching the law. 5 things. The legal anthropology of Pakistani ADR system. 1940 Act. India, because of the Justice Desai's judgment of Guru Nanak Foundation versus Ratan Singh's 81 Supreme Court 624, said that India needs to, people are laughing at the law and jurists are crying and weeping. Look at a new law India brought the law. Pakistan was a signatory to the Electoral Model Law of 1984. It's a 40 years old the model law which we never adopted, which we will adopt. What was the cause? The cause was the delay. The cause was that there was no party autonomy, 5 stages of arbitration, and what was after the anthropology, the theology of the law. That was my question to all of you today. But Haider, आपने बताना नहीं जवाब, आपने कल किसी ने नहीं दिया जवाब. Guess 84 years, 1940 law, all top lawyers are sitting with us here. This is 2024, we're making a new law. How many judgments were given by the Pakistani courts under that law? अभी नहीं आपने को सुन लिया? No ways, I did my research. No, you're not going to answer that now. No, because you heard that yesterday in Islamabad. I'm not going to tell you. You're not going to tell them now. अभी नहीं, वो अभी भी नहीं. Because issue is, when you look at the law and say how well the anthology of that law has been made. Is that law healthy? Is it law good? Is it law bad? And you can look at how courts have interpreted 1940 Act. 84 years, that law was with us. It choked the system, it delayed the system, it intervened the system, courts are interfering. Party says, we are not interested, we are going to the foreign wars. And thanks to to Barrister Makhdoom Ali Khan, the senior ASC, who then, with the Attorney General of Pakistan, got Pakistan, signed the New York Convention 1958, got Pakistan, signed the 2 ordinances called Recognition and Enforcement of Arbitral Award 2006 ordinance, which became the Act in 2011, is thank you to Mr. Makhdoom Ali Khan. But what will I do for 1940 law? Guess, 84 years, judges, 84 years. I think I told you not to mention, yeah. Okay, it is privity. This is the first issue of privity of information. No. Anybody guessing? Writing opinion to Goras, writing laws and coming to court. 84-year-old law. Pakistan, main country. 84-year-old law, 1940, Arbitration Act. Who has explained the judgment? I've given you judgment of Justice Shah. 2000, latest judgment was the Taisi case, 2024 SCMR page 640. Then last year, 2 judgments with Justice Shah again, 2000, and Justice Mashir Alam, in his very critical judgment, had to, with a bold word, wrote down and said, enough is enough. The Taisi, the Orient Power, 2021 SCMR page 1728, paragraph 24. Justice Mashir Alam said, we live in a global village, in a faster world. Pakistan has ratified the new UN Electoral Model 1984. Please, let's direct the government to do it. That was something 4 years ago. So 3 judgments तो मैंने गिन दी हैं आपको. अब कितनी रहेगी पीछे? 200, 400, 600, 84 years. वो ढूंढ रही है law site में, somebody is looking at the law site. Guess. That's a bad news. Only first judgment was 1950, PLD 1952, Privy Council, page 22, and last was Justice Shah. The entire judgments Pakistan made under 1940 Act is 46 only. That's why judges didn't push that law. None talked about party autonomy. None talked about less intervention. None talked about the very good judgment with Justice Hakim Nisar Sahab, PLD 2016 Karachi Dockyard case, where the principle of competence was discussed in detail, where the principles of less intervention were discussed. This is how the ecosystem will be built, inshallah. We have judges sitting here not playing golf now. Judges sitting here with you, speaking to you, that this is the system for Pakistan. We are there. Now, to conclude, I'll move to what my 5-minute story, I only have 5 minutes now. 5 minutes again? Huh. So issue is, what happened was, there were the laws on mediation in Pakistan, never touched upon. Every tax law has mediation. 89 CPC talks for mediation. Local government, Dr. Ishrat Hussain mentioned local government 2001 ordinance, mediation. But nobody went for mediation. Why? Because it's a consent of the parties. You have to ask the party. And just referring a matter to mediation is not mediation. I didn't do that. I did something which I learned from London. And I did it successfully. Everybody started following me, relying on me. And I'm very happy today that Yusuf Sahib is also, because his judgment is now quoted all over. This is his judgment. I'm carrying his judgment here. He's quoted all over now. I even cited his judgment now in another judgment recently where I appointed Justice Jilani Sahib as the mediator with this center. Was that the concept which came in England was a Hilsley case, where the Court of Appeal said, no, you cannot direct a party, bully a party for mediation, because party said, I pay the cost of your tax where you get the money. And I pay to my lawyer. But I will not go to mediation. You can't tell me to go for mediation. That was a scenario in England. Here is, again, what my logo I'm carrying nowadays, say no to litigation, say no to mediation, arbitration, and say yes to mediation. And I'll use in Karachi the theme. Yesterday I used this in Islamabad, and for Karachi logo, I'm leaving a logo for you. Solution for pollution is dilution. Solution for arbitration is mediation. Because section 31 of the new arbitration bill says that you can, during the arbitration, go for settlement and mediation. And what Siddharth in the morning was mentioning, what Zumak was saying, Singapore Mediation Center, when we were there together, George Lim said a very big case went there, and they went for arbitration then, after paying millions of dollars. Then they went to lawyers, then they went to arbitration, paying another $1 million. Then the lies of giving a mediation of $100,000, successfully done. I will say, when I was to get up from the courts in London, they say, Justice Hassan, you know the cost of this parties, both parties in this case today, legal cost, what my lord would be £3 million each. Queen's Counsel appearing in front of you, big law firms, Clifford Chance, Freshfields, big firm, Aaron Novery, appearing before you, the QCs. This is the cost of arbitration also. We cannot afford. That's why when I direct for mediation, we don't pay much fees to mediators, because this is something, a new concept in Pakistan. So what is that Helsley, that James Churchill went to the county and said, oh, there's a bush in my house which is poisonous. Please cut this, otherwise I take action against you. County said, no, you go for mediation. You cannot bully me to go to mediation. I will not go for mediation. I'm going to a court. He went to a county court. County court gave a judgment in his favor. Then he appealed to the district court. HJ said, I cannot decide your case because the judgment comes in my bar. And then the case went to the Court of Appeal. Happily, it came to Justice Geoffrey Vaux, Master of Rules, and Lady Suker, the first female Chief Justice of England, whom we were together in Doha. They held the court can direct the parties for mediation, court can manage the mediation, court can annex the mediation, court can attach the mediation, court can do the concept of the Harvard project on negotiation concept. Look at asking, because mediator cannot suggest, mediator cannot advise, mediator cannot give any suggestion. The court can be a bully guy and say, I am giving you a reality test. In my first case was a very big case. Justice Sarwana, the then lawyer, in 1989 filed in Pindi bench, Netherlands financed the Dutch bank, funding bank versus Morga Valley. A matter of 42 years came to my court. A winding up had been done, upheld by the Supreme Court. And the only issue was before me was, what is the issue? Payment of the debt under the winding up. I asked the parties. They were not coming to the point. Then I have to give them a reality check. A reality check was only one. तुमने जो पैसे लिए थे 40 साल पहले वो 300% बढ़ी है डिवेल्यूशन से. जो तुम्हारी प्रॉपर्टी है वो 2000 दफा बढ़ गई है. द प्रॉपर्टी दी देन ऑफ 50 करोड़ रुपए की वो 2 अरब की हो चुकी है.